Thank you so much for joining today. My name is Danielle Richards, and I'm the Director for Quality Practice and Education for Long-Term Care and Assisted Living at Providence Health Care. And just to assure you're all in the right Zoom, everyone is joining here today for the joint dialogue on aging between Providence Health Care and the University of British Columbia with the Edwin S.H. Leong Centre for Healthy Aging. Thank you all so much for joining us here today. I just want to start by acknowledging the lands on which many of us have the opportunity here to work and to share my gratitude that we live and work on the lands of the Musqueam, Squamish, and Tsleil-Waututh nations, and we are grateful to the Coast Salish people for these lands and water. I have the immense privilege today of introducing Wallace. And just before I do so, I want to share the program today. We will have about a 45 to 1 hour presentation from Wallace. And following that, we have around a 20-minute Q&A. I encourage any people who have logged on today to please share your questions in the chat, and we will answer them at the end of the presentation. If there's some questions that appear similar, we will do our best to join some together to share themes for everyone listening today. Okay, Wallace. It is with great pleasure that I get to introduce Wallace Robinson to all of you here today. Wallace is the leader for advanced care planning at Providence Health Care. Wallace has dedicated more than 3 decades to supporting patients, residents, and families through some of life's most important healthcare decisions. After earning his Master's of Social Work in Toronto in 1993, he joined St. Paul's as a social worker in the kidney transplant and HIV/AIDS unit. Since 2015, Wallace has led program development, supported education, and policy initiatives focusing on both ensuring patient care aligns with individual goals and that wishes through advanced care planning and goals of care conversations are achieved. Wallace is always guided by Providence Health Care's values of diversity, dignity, and justice. And Wallace has championed efforts to make advanced care planning accessible and meaningful for all members of community beyond those just in the St. Paul's setting. Wallace is particularly focused on those experiencing vulnerabilities as well. He's also contributed to the development of trauma-informed approaches for serious illness conversations when those conversations need to occur, and he's helped advance more equitable palliative care practices across Canada. Wallace today will present on what matters to you, the essentials of advanced care planning in BC, and his goal is to help us better understand why advanced care planning is more important than ever, and how individuals can ensure that their healthcare decisions reflect what really matters to them. Over the years, I've had the privilege of sharing office space alongside Wallace, and so I'm very pleased today to share this platform with him. Over to you, Wallace. Thank you.
Wow, Danielle, thank you very much. That's a very kind introduction. And hello, everyone who's tuning in this afternoon. It's a beautiful day out there, and the World Cup is on, and Wimbledon is on. There are lots of other things to do. So thank you for joining us, and I hope you'll find this session informative. It's really challenging around advanced care planning because there are many layers to the information about advanced care planning. You can go into the nuts and bolts and details of the legislation in British Columbia, which guide advanced care planning and consent, which I do with our healthcare providers, so they're well informed. But I'm not sure that you necessarily want all of those details, nor do we have time to go into all the legislative details. So I'm going to try to do my best to give you the key points of advanced care planning. And some of it, forgive me if you already know, hopefully if you are well informed around advanced care planning, some of this will help clarify and reinforce your own knowledge and empower your own knowledge. And if it's new for you, hopefully you'll learn something and think for yourselves about what I can do to engage more in my own advanced care planning. I will say up front, as Danielle mentioned, I'm a social worker, not a lawyer. And so please don't take anything that I say as uh, a legal truth for you. I think in all of this, it's important if you have any questions of a legal nature that you speak to a lawyer or a notary. What I hope to present to you is really um, the public knowledge about what advanced care planning is and what we in healthcare think of as advanced care planning, and how it informs how, as healthcare providers, we take care of patients, we take care of those who we are entrusted to look after. So I think this is about being prepared. As Danielle mentioned, I've been doing this for a long time, and now I'm talking about advanced care planning as a senior myself. So, and a couple of years ago, I was treated for leukemia for 8 months on chemotherapy. So I had my own experience of wondering, well, what was in my future and how long I might have to live, and think about how I personally was prepared. Because the truth is, as we embark on a journey like this, a journey in this picture, we don't know what's likely to be ahead for us. And advanced care planning is really doing what we can to be prepared. Um, in other words, it's a little bit about getting our ducks in a row. That's always what comes to mind for me. And I looked this up today as I was preparing the talk or finalizing the talk. Like, what does it actually mean to have our ducks in a row? And that phrase, which comes from, been around for a long time, is to be well prepared or well organized for something that is going to happen. And what we know is going to happen is, as we get older, we're likely to encounter some medical issues. We're likely to face questions around what we would want if we get sicker, as we get sicker, or maybe a loved one as they get sicker, what their wishes would be. So we know that's going to happen. We should be prepared for that, and we should have our ducks in a row. Now, here, I hope these are ducks. I love these 5 ducks here, and I'm going to use that as an analogy and kind of to help orient us throughout the talk here. But really, to go through, there are really 5 aspects I think of, like broad advanced care planning for the future, or broad planning for the future, is to think about what are my healthcare wishes? What are my personal care wishes? Like, think about preparing from that perspective as well. There's financial and legal preparation. There's estate or will preparation. And there's organ donation. So it's really quite complex when you think about it, when you break it down. There are 5 kind of domains. And interestingly, each of these domains are governed by separate legislations in British Columbia, separate laws. So they all have a little bit different terms of nuance and terminology and what we should do to be prepared. So for us today, the primary focus is going to be on health and personal care, which is really the umbrella, under the umbrella of what we call advanced care planning. As healthcare providers, we talk about advanced care planning, and we're really talking about what your healthcare wishes are, what your personal care wishes are, because those are the areas of care that we provide, and we want to ensure that what matters to you in those areas is what we provide. So advanced care planning is expressing, by definition, our health and personal care wishes for the future, especially for thinking about a time we might not be able to communicate for ourselves. It might be about do not resuscitate. It might be about written documents or written forms, but most of all, it's about the conversation. And advanced care planning is really also about consent, right? It's about what we consent to, what we would want, and what we would consent to if we got sick and couldn't speak for ourselves, and who we trust to ensure that what is consented for aligns with our wishes or instructions. So I think when you look at why this is important, it helps ensure we're prepared for the unexpected. And really, it's important to think and be aware that medical care has become increasingly complex. We can't anticipate every possible circumstance that we might encounter as we age and as we approach the end of our lives. But it's important that we think about what our values are and what is acceptable to us in terms of treatment and outcomes, and have those conversations with the people who are going to be asked to make those decisions for us. Advanced care planning can help prevent conflict amongst families. And I can say, as a social worker, I've seen many times when there's been conflict around decisions to make on mom's behalf. If there are several children and there are disagreements, the children don't get along that well, it can be a lot of conflict if we don't actually know what mom's wishes were. Whereas if mom's wishes are clearly known, they've been expressed to everyone in the family, or they've been written down, or they've been discussed with their healthcare provider, can really help prevent significant conflict within families. And from another perspective, it can also relieve the burden on family or loved ones. And I recall many years ago now, over 30, when my father had a stroke and was in the ICU, we had some really difficult decisions to make as a family. And it really felt like a burden to make that decision about whether to dad would want to be resuscitated, if the outcome was likely to be poor. It was a painful experience for all of us. And if we had known, because we had never had that conversation as a family, we were left without that knowledge, and the burden was on us to make that decision and to struggle with that on our own. I think another important aspect is the protection of our autonomy. That what matters to us, what I want is known, right? I think most of us, or many of us, joining this Zoom call today are probably of the baby boomer generation. And we've really, as a generation, have really been a lot about nothing about me without me. We've really wanted to be empowered around our own autonomy. And I think that's important, and around why advanced care planning is important as well. Excuse me. So, advanced care planning is thinking and talking about, if I became unwell, what would be most important to me? What would be most important to me? What would my goals be? Would my goals be to live as long as possible, no matter what the side effects or what I had to go through, or even if my quality of life was diminished? Would that be my goal, or would be my goal to be more to be focused on comfort care, to be at home, to be with family, to have music around me? What would be most important to me if I became very unwell? Or you might think about it in terms of, if I'm approaching end of life, what would be most important to me around the care and what happens to me at that time? And then to think about another question, the flip side of that. What would I be most concerned or worried about? What would I be afraid of if I became very unwell? Is there anything there that I might want to voice or to be clear about? And then another question we could ask ourselves is, how much hospitalization or treatment or intervention would I be willing to go through for the possibility of living longer? These are questions that are part of what we call a serious illness conversation, which where as part of my role, really encouraging healthcare providers to engage in these conversations with people who come into hospital who are diagnosed with a serious illness. Maybe their life expectancy is or prognosis is poor. And we really want to ensure that our motto at Providence is how you want to be treated. We want to make sure then that we ask the questions about how someone wants to be treated, what's important to them, so the care we provide for them aligns with those wishes, right? And then another important aspect of advanced care planning is thinking about who would I want as my decision maker if I couldn't make decisions for myself? Because the laws in British Columbia are very clear that the healthcare provider must turn to someone to make decisions for me if I'm not able to make decisions for myself. The healthcare provider is not allowed to just make decisions that they think are best for the patient. They need to consult with and receive consent from someone close to the patient, someone who is appointed as their substitute decision maker. So it's important to think about who would I want as my decision maker? And we're going to talk in some detail about how that looks in British Columbia. And then to ask myself, have I spoken with them about my goals and concerns, about those questions I asked just a minute ago, what's most important to me, or what would my concerns be, right? So who would I want my as my decision maker? Have conversations with them about goals and concerns, and then think about whether I should appoint someone to be my substitute decision maker by making what in British Columbia we call a representation agreement. That's the document in BC where I can appoint who I want to be my decision maker legally as in a representation agreement. So I'll talk a little bit more about that in a minute also. So I think one of the points I want to emphasize as well is that advanced care planning may include writing things down and preparation of legal documents. And I will be talking about a couple of the legal documents in BC. But I think most of all, most importantly, it's about the conversation. It's about the conversation we have with the people who would be our substitute decision makers, with our family, with those who are likely to be present or around if we become sicker, and also having conversations with our healthcare providers about what's important to us as well. For me, it's my family doctor, it's my oncologist. Those are the people that I should also ensure that I'm having conversations with. And if I've made a legal document, providing a copy of that legal document to my healthcare providers, to my oncologist, who will make sure it goes into my health record so it's available when I'm admitted to hospital, or with my GP so he has it in his files in case the hospital calls him and says, hey, we have Wallace here. Can you tell us anything about his history or his wishes? Because he's not able to communicate with us right now and he's quite unwell. So just briefly, a one-slide history of consent and advanced care planning. Just so you kind of have a context and background for this. I find it fascinating. It's an interesting story of how this has evolved over time, and even in my career as a social worker in Vancouver. So really, prior to the mid 1900s, it was all about doctor knows best. It was really the physician who determined what was in the best interest of the patient. The physician determined what the risks and benefits were and made a decision and said, this is what we're going to do, Wallace. This is the treatment we're going to provide with you. You're going to have surgery next week. And there was really not so much, there wasn't necessarily a lot of conversation or engagement or details about the risks and benefits. There were two landmark cases in Canada in 1980s where patients sued their doctor because there were bad outcomes, and the patient said, I wasn't informed about these risks or the benefits of this treatment that was given to me. And I have a right to be informed and to make that decision for myself. Though the landmark cases really started to establish patient-centered care, that it was patients who get to decide, and under the law, patients must be informed of risks and benefits. There was an interesting case in Ontario that went to the Ontario Court of Appeal in 1990 that established in case law in Canada an important concept. So this is Mrs. Millette. She was in a very serious car accident in which her husband was killed. She was brought into the hospital in Kirkland Lake, Ontario. She was bleeding profusely. And in order to save her, Dr. Schulman, who was the doctor on call that night, proceeded to provide blood transfusions to her. It was necessary, he thought, or he saw in his clinical opinion, to provide the blood in order to save her life. And while he was proceeding to provide the blood transfusion, a nurse found in her purse this little card that said, I'm a Jehovah's Witness. I do not want blood transfusions under any circumstance. And what happened in this situation was Dr. Schulman was faced with the decision, do I provide the blood transfusion or not? If I don't, she will die. If I do, it looks as though she said she doesn't want it. I'm going to do it anyway. And what happened was that Mrs. Schulman survived. Mrs. Millette survived, and she sued Dr. Schulman and was won nominally in the Supreme Court of Ontario. And what that judgment established was that a competent adult's prior clear refusal of treatment remains legally binding, even in a life-threatening emergency where the patient is unconscious. It really established in law in Canada that our wishes, our instructions, where they are clearly known, must be followed. If they're not followed, the healthcare provider can get in trouble, as Dr. Schulman was in this case. So it really established again the importance of consent and advanced consent and the importance of people's wishes and what they want done to their body, do not want done to them, must be respected. And then, kind of following that, in the next decade or so, you saw provinces across Canada, including in British Columbia, establish legislation which provided all of the kind of parameters and the outline and the guidance around consent and advanced care planning that we are going to be talking about today. So our act was Healthcare Consent Act, came into effect in February 1st, on February 1st of the year 2000, along with what we call the Representation Agreement Act. This might be a good point to point out that legislation varies from province to province, and in the United States, it varies from state to state. And what's particularly different, they're all kind of similar, but not exactly technically exactly the same. But what is often quite different is the names of the different documents. So in British Columbia, we have this thing called the Representation Agreement. In Ontario, they don't have something called a Representation Agreement, but they have a general equivalent called an Advanced Directive for Healthcare. So that can, I think, adds to some of the confusion that we experience as a public in Canada. There are different terms. We're not sure necessarily of what term is relevant or the language of our province, of our jurisdiction, which is really important to know. So when I think of what is the impact of advanced care planning, what does it actually do? Um, I think about it in this way. I think we on the one side we have this arrow, this flow of the patient's wishes, their goals of care, cultural or religious considerations, what's acceptable in terms of quality of life to the individual. And then from the other side, from the other direction, we have the medical understanding or the um, physician or provider understanding of the prognosis of my disease, the what baseline functioning I'm likely to have after a certain treatment or maybe after a medical event, and the risks and benefits of intervention. And then really bringing those two streams, those two directions of knowledge, understanding, of wishes into alignment. And that, I think, is the power of advanced care planning, and that's why it's important for us. So let's go into kind of three key options for advanced care planning in BC. And remember, I'm talking about those first two ducks, health and personal care. I will come back to the last three ducks if we have time, just for a quick slide and overview of the key points of each of those areas of planning. But the focus is going to be around health and personal care. So in BC, we kind of have three options for expressing our wishes for care in advance of a serious illness. So one we kind of think of as a basic advanced care plan. It's expressing our wishes, maybe verbally, possibly in writing, to guide the person who's going to end up making decisions for us. And if we haven't appointed that person in advance, in British Columbia, when I am admitted to hospital, if I haven't appointed somebody in advance to be my representative, the healthcare provider must appoint, and I'm not capable of making decisions for myself. That's an important point to add there. The healthcare provider must appoint a temporary substitute decision maker. So it's kind of in a way taken out of my hands as a patient, because the healthcare provider is making the decision about who's going to be my temporary substitute decision maker. I'm going to go into more detail around that in just a second here. I'll just name the other two options first. So the other is that representation agreement, which I've named now maybe 10 times already. And that's where we would express our wishes, and a legal document to appoint who I want to be my substitute decision maker. And then finally, there's the thing called an advance directive. Now, I will just say in my experience, what we see about 90% of the time at least is number one. People have had conversations with, or maybe written down some wishes, had that conversation with a family member, or with the healthcare provider, and we follow the rules of appointing a temporary substitute decision maker. That's what we see most often because most people haven't taken the step of creating a representation agreement. Maybe 10% of patients that we see at St. Paul's Hospital and really across Vancouver Coastal have created representation agreements. And that's where the person has gone ahead and thought about who they want to be their decision maker and made that appointment. I'm one of those 10%. I have made a representation agreement. I have appointed the person I want to be my decision maker. So there's no doubt about that. And then finally, there's something called what I mentioned as the advance directive. We see maybe in 1% of the time, very infrequently in BC, do we see an advance directive, which is an instruction that's binding directly to the healthcare provider. I'll come back to that, to numbers 2 and 3. But let's talk a little bit more about number 1, a basic advanced care planning. What does basic advanced care planning involve? So I think I've kind of mentioned this, but in BC, the healthcare provider must appoint a temporary substitute decision maker when a patient becomes incapable of providing informed consent for a specific medical treatment, and there's no other legal authority or document in place, like a representation agreement or an advance directive. And the healthcare provider must follow certain guidelines in the legislation around how the healthcare provider appoints that temporary substitute decision maker. The legislation says there's a hierarchy of relationship. And first, we would look to does this patient have a spouse? That's anyone living in a marriage like relationship, including same sex partner. Is there an adult child? And that's anyone, any child. There's no distinction between which child would be the decision maker. There's no guidance around which child to choose under the legislation. Is there a parent? Is there a brother or sister? We go all the way down this list, all the way to a person immediately related by marriage. So this is to guide us if we're not sure about who this person would want to be or should be this person's healthcare decision maker or substitute decision maker. It's to provide guidance to us around who's closest to the person. Now, the important thing to think about here is if the person that you would want to make decisions for you is in fact your spouse, then you probably don't need to worry so much about making a representation agreement because your spouse is the person we're going to turn to. But if your spouse is someone who maybe you think might be too distressed to make difficult decisions for you, or maybe it's not a good time in your relationship and we don't necessarily want that spouse to be making decisions for us, then that's a time to think about whether I want to rely on this framework for who gets to make decisions for me, or whether I want to take things into my own hands and create that representation agreement. It's, now, the other thing is if your spouse is happy to defer to another person. So let's say your spouse is on this list. You've had conversations with your spouse and said, look, I think I want our oldest child or our second child because he's the social worker to make decisions for me. As long as your spouse says that's fine with me, I have no problem with that, I agree, and you trust that your spouse is going to act according to your wishes at the time this appointment's going to be made, then that's fine. You don't need to go ahead and make a representation agreement. Again, I think about the representation agreement is really most important when there's potential conflict in the family, when there's potential dispute. Maybe you only have children, there's no spouse, and the children don't necessarily get along very well, or maybe might not be able to agree, have different points of view. Then that's a really good time to be thinking to myself, maybe to ease the burden and distress on them and to make things clearer and simpler, I'm just going to choose myself who I want to be that decision maker. Or maybe you pick someone further down the list, not necessarily someone closely related, but maybe it's a friend who's a physician or a close friend who you trust to make decisions for you. So that's what the temporary substitute decision maker and having a basic advanced care plan looks like. Some limitations on this, as I've really just outlined, the person we trust most might not be the person who's appointed for us. So that's something we should really think about. There's another limitation here, which is the temporary substitute decision maker under the legislation does not have the authority to refuse life-sustaining treatment unless there is agreement among the healthcare providers that this refusal is medically appropriate. In other words, and maybe you are really quite clear, like Mrs. Millett, I don't want a blood transfusion under any circumstance. Um, I think that in that the the healthcare providers might not necessarily think that this refusal is medically appropriate, and they might have difficulty trusting or following the TSDM's refusal of that treatment. So this the TSDM has some limits on that refusal of life-supporting care or life-sustaining care. Um, and then the temporary substitute decision maker is not authorized to make personal care decisions. And this might probably should have mentioned this earlier, but the difference between healthcare and personal care, what are those, right? As domains or as decision-making areas. Personal, so I'll start with healthcare. Healthcare really, I think, is we all probably have a good guess that healthcare decisions are about what happens to me, what happens to my body, what happens to me in terms of treatment, medications I take, what maybe medical research I consent to. That's what we think of as, that's what defined as healthcare. Personal care, personal care decisions are about where I live, who I hang out with, um, where I go, what I eat. Those are all kind of personal care decisions. And they're important decisions as well. The temporary substitute decision maker does not have the authority to make those decisions on a patient's behalf. So there's a gap there. There's really no one under the law in the framework of consent in British Columbia who would be authorized to make personal care decisions for a person who does not have a representation agreement. So that's something that might be important to a lot of people and to think about. So I'm going to leave that for now. I'm sure there are questions, and I know I think Danielle is following the questions that are noted in the chat, and we'll have some time to answer those at the end. So let me go now to, we talked about relying on the temporary substitute decision maker. And again, I just want to emphasize the importance of the conversation that you have with that person who would be your temporary substitute decision maker. And you may wish to write your wishes down, and you can use a form for that, or even a piece of paper. However you express your wishes in British Columbia, the legislation says those wishes must be followed. Okay, so now let's talk about a representation agreement. There are two types of representation agreements. I'm going to just talk about the main type, which is called a representation agreement section 9. I wonder if at this point, Jamie, you could put a link to the My Voice book in the chat. So people, many of you may be familiar with this advanced care planning book called My Voice. It's an advanced care planning guide for British Columbia. It's been around for a long time now, almost 15 years, I believe. And in this document, you will see guidance for how to create what advanced care planning is. A lot of what I'm talking about today is in the My Voice book. And then also there are forms in the My Voice book where people can make their own representation agreements or advanced directives. I just want to say I encourage people, if you can afford it, to talk to a lawyer or notary about your advanced care planning. And if you're going to make a formal document, it's good to consult a lawyer about those. Although in British Columbia, it is not necessary, and we do accept representation agreements in healthcare at St. Paul's Hospital, VGH, any other hospital in BC. We accept these these documents created by individuals, as long as they're signed by the individual and there's two witnesses who are adults, and not the representative as named in the representation agreement. We accept those documents. So again, the My Voice book has this document. The representation agreement, section 9, is for adults who are capable of making decisions and know what they're doing. I think anyone who's joined this call and knows how to navigate Zoom and join a session like this is probably quite capable of making a representation agreement, section 9. The other document that exists is called a representation agreement, section 7. That's a document for somebody who lacks capacity, does not have the capability to fully meet the legal requirements of capability. So they could not sign a legal document around a representation agreement, section 9, but they do know who they trust. And like, think about maybe somebody who has Down syndrome or somebody with a disability. They may not be able to create a legal document as we think of them in a court of law, but they do know who they trust, and there is a document for them that they can use to appoint that person to be their representative. But for us, it's a representation agreement, section 9. I'm going to pop out of here, go into the My Voice book. And so I'm in My Voice now, if you are as well. The representation agreement form is on page 44. It's the buff colored pages. And it just shows how you can create this document for yourself. You fill in who's made the document. It's me and my address and my full legal name and who you appoint to be your representative, the person you are trusting that you are appointing to be your healthcare decision maker. And optionally, you can appoint someone to be your alternate if your representative should predecease you or resigns. You can have that alternate can step up and be your representative in that case. And then there's a section for you to put down any instructions or wishes you have for your representative. You sign it, you date it in front of your witnesses. It's important to have those witnesses there to witness your signature. This is where the adult signs the representation agreement that they just created, and they have 2 adult witnesses. And then to make it fully legal, the persons that you've appointed to be your representatives should sign the document as well, that they have agreed to be your representative or alternate representative. So those are the key points of the representation agreement if someone decides to create that document for themselves. If you do, it's important that you keep the original copy of this. If you have a photocopier, great, make a few copies. If you don't, go to Kinko's or wherever people go to get copies made these days. So you can provide a copy to your representative, so they have a copy that they can show us when you're admitted to hospital. Maybe you can't speak for yourself. Your cousin Joan is your representative in this document. They have a copy of the representation agreement. They show it to me as your social worker. I'm like, oh, there's perfect. This person has created a representation agreement. Here we go. We can put that in your health record. Give a copy to your healthcare provider. Another important thing to do. I think if you have a lawyer and your lawyer creates this representation agreement for you, they will encourage you to do the same thing. Keep a copy yourself, give a copy to your representative, have a couple of extra copies on hand to provide to your healthcare provider or to your or to the hospital if you're admitted to hospital. So that's really the nuts and bolts of a representation agreement. It really authorizes your representative to make any personal care, major, minor health care decisions, refusal of life-supporting care, if that's something that's important to you. If it's necessary that you're not able to live at home, and you've lost capability and ability to manage at home, they can provide consent for you to move to a care facility. An exception is that does not include financial or legal decisions. That's going to be the enduring power of attorney document. That's one of those other ducks we're going to talk about in a minute. So the Section 9 rep agreement, it's also called an enhanced representation agreement, major minor health care, personal care, and refusal of life supporting care. So that's that one. The final document I'll mention is that advanced care planning document that I'll mention is the advanced directive. You'll recall that I mentioned that this was something we see maybe about 1% of the time in British Columbia. That's because this document is it's what is called an instructional document. What you write in here is legally binding on the healthcare provider. So actually, if Mrs. Millette were here and she said, I'm a Jehovah's Witness, I don't want a blood transfusion under any circumstance, what should I do to make sure my wishes are followed around this very clear instruction I have? I would suggest to her, Mrs. Millette, you probably want to create an advance directive because that's legally binding on the healthcare provider. It bypasses a substitute decision maker and is meant to be a legally binding instruction on the healthcare provider. So I caution people about using this document because it is so strong. Unless you're very, very clear that you're not going to change your mind about whatever instruction you put in here. I think, and the research suggests the best type of advanced care planning is the conversations with the person who's going to be your substitute decision maker, either the temporary substitute decision maker that's appointed when you're admitted to hospital, or in the representation agreement, the person you trust to be your representative. Those conversations and that individual being able to be in the moment, having conversations with your healthcare provider as the situation is unfolding and the treatment options become clear. One of the things that's difficult, and one of the reasons I mentioned that healthcare has become increasingly complex, one of the implications of that is that there are so many possibilities for how we might get sick, the type of illness we might have, and the type of treatment that might be available. It's impossible to anticipate all of what might happen and to put those written down one by one in a document. I would want this type of chemo, but not that type of chemo. I want this type of heart medication, but not that type of heart intervention. Very difficult to do that. Much better to have your trusted substitute decision maker who knows you, who knows your values, who knows I don't want a lot of invasive interventions unless it's likely to bring me back to where I previously was, or unless it's likely to preserve at least a minimum of the quality of life that's important to me. That person knowing what's important to you is really the best type of advanced care planning, in my opinion. So it's a lot of information. I hope everyone's okay. I'm going to I spent most of the time on the first two ducks. Now I want to just move quickly to those other three, right? So we've talked about health and personal care under the advanced care planning umbrella in quite a lot of detail. I hope I haven't confused you too much. Now let's talk about the remaining three. And I just have one quick slide, high-level points on each of these. So the middle guy, the financial duck. In British Columbia, if you're wanting to prepare for the future for your financial planning, the document is really called a power of attorney or an enduring power of attorney. So The enduring power of attorney is the type of power of attorney that comes into effect if or when we become incapable. There are other types of power of attorney. I could go to my lawyer and say, I need a power of attorney because I'm going out of the country for 6 months and I've got this piece of land I'm going to sell and I want to appoint my partner so they can sign off on that sale of property. That's called a power of attorney, and it's short term and it's usually for a specific purpose like that. The enduring power of attorney means it comes into effect when we become incapable. It doesn't come into effect until then. It appoints someone to manage your financial and legal affairs while you're incapable, perhaps, but you're still alive. It's not the enduring power of attorney, or the power of attorney document is not under that authority, under that document, able to make healthcare decisions for you. That's the representation agreement, not the power of attorney's job. We can't accept an enduring power of attorney in the hospital to make healthcare decisions for people. And that's not always clear generally to the public in BC. The other thing that and it's also your power of attorney does not exist beyond the end of your life. Then that power of attorney responsibility or role ends at death. It's the document for our financial decision making while alive. It may be done without a lawyer or a notary, but caution on that. I think you'll find that most banks in British Columbia wouldn't accept a power of attorney or enduring power of enduring power of attorney document unless it's notarized by a lawyer or a notary. So this is one document where I think a lawyer or a notary is almost a must. So encourage you to, if you're thinking about all your planning, we're doing that future planning we talked about at the beginning, this is the one for financial and legal decision making. So then next we move to estate. Estate planning, of course, that's what happens in your will. That's really, we're focusing on will planning. It's a whole different set of legislation than anything I've talked about previously in the last hour. This ensures your assets are going to be distributed according to your wishes after you pass away. I think everybody knows that. It appoints someone you trust, you nominate, you elect to be your executor. I think it's the more assets we have, the more complicated our situation is, the more people we have in our family, the more important a will is, and the more important it is that you consult or involve a lawyer or a notary in completing your will and your estate planning. Without a will, your preferred loved ones might be left out, of course. And again, you can do, and I have seen times people create a will without a lawyer or a notary, but they tend to be people with maybe on income assistance who maybe don't have any assets and just have a few belongings that they want to make sure go to a friend or a family member, and they want to designate that in a will or an estate, and they don't have a lot of money to consult a lawyer or notary. Those are the kind of rare circumstances where you see wills being created without lawyer or notary involvement. And then finally, organ donation. Now, I know I'm a senior and I can't see all of you, but I imagine some of you are as well. I did a little research on this before this presentation, and I read some things that I didn't know. So I'm learning things as well today. Did you know that there's no upper age to being an organ donor in BC? That the oldest organ donor in BC was 79 years old. That's to date. And in Canada, organ donor, the oldest was 92. And we've had tissue donors in the country as old as 104. So I think that really says anyone can be a donor. The BC Transplant Society, which manages transplant in this province, says even without chronic conditions, you should register and let specialists decide if what organs or tissue are appropriate for donation. They're the ones to decide, not necessarily based on our age. It's important to note that in British Columbia, family consultation in BC is mandatory. So I might say I want my organs to be donated, but after I die, I've reached brain death and decisions are being made about my organ donation. Even though I've registered as an organ donor, my family can override that if they say, no, that's not what he would have wanted, or no, we can't. We can't stand the idea of that organ donation happening. They have a say. So it's important to have conversations. It's just another reason that we should be having these conversations with the people we trust. And then you can register at register.transplant.bc.ca or Google register British Columbia transplant. You'll find it. It's easy to register online. So those are all our ducks. You'll be glad to know there are not any more ducks hiding on either side here. That's enough for 1 hour, for one day. I would just add, just at the end here as I close, a really wonderful book on this topic is by Atul Gawande, Being Mortal. It's a few years old now. I think it was published in 2014. It's a wonderful book about mortality and medicine and how how important it is. Medicine has become increasingly complicated and how difficult these decisions can be around what happens to us at end of life and how important it is for us to do our job as citizens in thinking about what we would want and having those conversations with our family, and how important it is as healthcare providers that we as healthcare providers do a better job of engaging in these conversations with the public. Lovely book, highly recommend. And now I think it's question time. You'll be glad to know.
Wallace,
I'll be
thank
quiet.
you. Thank you so much for that incredible presentation. I also agree with comments in the chat there, a comment from Janet that this is very thorough and helpful, and lots of information there that many people didn't know. We know that often information does change and shift. And so we will provide all the links and adjoining documents that are able from the presentation. We do have a number of questions that I've noted from the chat, and I really appreciate your getting ducks in a row. I like this symbol that you've created. The first question is around if a resident in BC were to be outside of BC, does the representation agreement apply? Complex question, perhaps.
It is. Well, that's a yes and no question. I get asked that a lot, kind of reverse. Somebody from Ontario comes to BC and they have the Ontario version of a representation agreement. And the strict answer is no, it doesn't necessarily apply. In British Columbia, for that external document to apply, it needs to be certified by a lawyer in Ontario that it meets all the requirements of the BC legislation. So it's almost on a case-by-case basis. But on the other hand, that document from Ontario, we would see in British Columbia as, wow, this person very clearly wants this person to be their decision maker. They've said these things are their wishes. We will do our best to align their care with those wishes as expressed in that document. And the reverse is true as well. So strictly speaking, it doesn't technically apply in other jurisdictions, but most likely those wishes will be respected as written in that document.
Okay, that's great to know for people who do want to travel but have their wishes noted and organized to take along with them.
Absolutely.
Yeah, that's great. A couple other questions that I've joined together that are a bit similar is it possible to appoint two people as a joint substitute decision maker? What's the pro and con with that? And can you have more than one person as part of your representation agreement? And is that a good idea?
Yeah, so you can. That's something you should normally I would suggest involving a lawyer or a notary in creating that type of joint appointment. I think as long as you believe that the two people you've appointed will get along, and maybe you have a conversation with them and say, "Hey, I want to appoint you both. Are you both good with that? And will you promise to get along? And these are my wishes. Will you promise to follow them?" I would be most concerned about thinking about what are my wishes and who is most likely, how am I most likely to, how can I ensure that those wishes are going to be followed. If it's one of those two people I trust the most to do that, I might consider just appointing that individual person. If I feel that they could do a better job together and they would support each other in that way, I can appoint them both to be co-representatives. So a lawyer or notary, I think, is the best place to have that conversation. NIDIS, which is an agency in British Columbia, previously had a document where you could co-appoint those people. I haven't seen it lately. I don't think it currently exists. So my suggestion is a lawyer or notary for that.
Yeah, there is a comment in the chat from Miriam around the NIDIS documents that are available that you can offer a free representation agreement through that website, and maybe you just need a witness for that signature. So perhaps it's a different
It's
avenue.
a well, they offer very similar documents to the ones that we looked at today, to those forms that I put up on the screen. I personally, as a social worker in healthcare, prefer to use the documents that have been created and published by the Ministry of Health and the Attorney General's office, which are in my voice. Those were created explicitly by the government of BC. Nidus has created some. They're a little bit different. They're generally they're fine as well. I just tend to lean toward the British Columbia created ones.
Okay, that's great. Another question is around the most, so the medical order for scope of treatment, and just
Right.
questions around perhaps what is that? Is it that's where you document invasive treatment preferences or invasive interventions? I know different health authorities will call it different things, from code status to most. And
That's
so maybe
right.
just your thoughts on that.
So most stands for medical orders for scope of treatment. And it was initially envisioned really as a medical order. It's meant to guide decisions affecting the direction of care while you're in hospital or while you're in care. It that most form has really it's expanded in some areas to be used in the community as well, almost like an advanced care planning type of document. Um, I think there are many forms that advanced care planning documents can take. One advanced care planning document might be, we could call that the representation agreement, and where you've written your wishes or instructions, that's a type of advanced care planning document. I could just write on this napkin I have right here my wishes or instructions, and the healthcare provider is bound by law to follow these instructions or wishes as long as they're medically appropriate. As long as they are legal, as long as they are appropriate to my care, the medical provider must follow those. And it's similar with the most. A most is another form of advanced care planning document used in some jurisdictions. It uses differently in different places. It's not exactly a binding advance directive, but it is another clear expression of wishes, which is supposed to help guide the decision making if we become sick and can't speak for ourselves. Remember that all of this is about advanced care planning. It's really about when I can't speak for myself. when I can speak for myself, I voice my wishes. It doesn't, I don't, you don't refer to my piece of paper. I'm in the moment and I can express that. I did notice there was a comment in the chat, a question about what about MAID, medical assistance in dying, and maybe I'll just mention that now as well. So the reason that I don't often talk about medical assistance in dying in advanced care planning is that you cannot give advanced consent for medical assistance in dying. If I put that on this piece of paper and I'm not capable of providing that consent at the time that medical assistance in dying is being discussed, it's not medical. You need somebody receiving medical assistance in dying needs to be able to provide consent for that. I need to be able to provide consent for that myself. So under the legislation in Canada, I cannot provide advance consent for that. That's the way the law is at the moment, at least.
Thank you. Yeah, you saw that question there. The napkin has taken a journey of its own here, and the question is, does the napkin voicing your wishes in that moment, does it need to be witnessed?
No, no. What we're interested in as healthcare providers is, are these wishes reliable? Like, the reason, if I write, instead of writing my wishes on the piece of napkin, I write it on a formal document, that's going to be seen as even more reliable than this. If it's witnessed, that adds another layer of reliability. If it's witnessed by a lawyer or notary, that adds another layer of reliability. So it's really about, how can I rely on the wishes that were expressed, however they were expressed, being true and accurate. I had a woman, I was doing some public education once for a group of Indigenous elders, and one of the women said, I have recorded my wishes in my phone. And although, we can't store those wishes on your phone, we don't have an ability to store those voice messages in our health record in hospital. That's a very powerful expression of wishes. We would absolutely follow those wishes if they were appropriate and legal and appropriate to the health situation that I currently found myself in, and we needed decisions around. Right? And we just want to know, to be sure that we're following your wishes and they're your most current wishes. Your wishes haven't changed. So if I probably wouldn't use this napkin unless maybe something was going to happen to me later today. Like I knew I don't know, I was getting sicker and something could happen. I just wanted to write something down quickly, and I'd sign my name and date it, and that might be really valuable to my partner and my family member, and the healthcare team, if decisions need to be made after that.
Mm-hmm. That's great. It also sounds like you might be creating a second job for yourself here and creating an app for voice recordings, perhaps, or maybe it already exists for that in particular.
I don't know that it does. Maybe it does by now. Last time I looked, it hadn't, but that was years ago, to be honest.
Mm-hmm. One question here about being practical in the approach is, what is the options of appointing a substitute decision maker that doesn't live in the same province? Is that maybe not the best idea if they can't be there in person?
Look, I think it's totally fine to have your representative be living in another province if it's somebody you trust. Oh, that's a good point. I just see that point from Lorraine Weir. Sorry, what's the name? But voice recordings can be translated by AI into paper. That's a really good point. And so we could easily store that document in the health record we're able now in our Cerner health record to scan advanced care planning documents and save them in an advanced care planning folder. Sorry, I lost my train of thought. What was the question?
The question was just if you have a substitute decision maker that you would prefer to appoint, they don't live here.
Absolutely. I mean, we can that happens often in healthcare, where we're calling a family member who lives in the other province. We may be in touch by email with them. There are lots of ways to stay in touch these days, so that doesn't absolutely eliminate someone to be your decision maker. The important aspect is, do they know you? Do you trust them and their decisions on your behalf? And will they make themselves available?
Okay, that's great. And one last comment there around MAID is just commenting, of course, on the Catholic Hospital at St. Paul's. And so in terms of MAID, as Wallace has mentioned, just seeking that other care through having time in advance and having that consent. Yeah.
Yeah, planning in advance is really important in all aspects of what I've been talking about today. I think what's wonderful is that it's such an engaged group who are obviously thinking. Probably most of you have a lot to teach me about your experience around advanced care planning. I think planning for the future, like just to sum up, planning for the future is so important, and especially as things have there are more and more options, and things can be complicated sometimes.
Yeah, and as you say, things do evolve. So, in terms of
They
all
do.
the information shared here today, we will have a recording on the Dialogue on Aging website. And you have the ability to go back through the recording. There was a significant amount of information shared, which is impressive. And thank you very much, Wallace. It really gives everyone the ability to take notes of where something might be more meaningful and more important to work through. So this information will definitely be made available. I think we've answered all the questions in the chat there, and I've collated a couple. So thank you so much for all this content. It's really nice to be able to have a speaker present meaningful tools for people to take away, not just information to add on, but something that we can also action that people feel supports them. As all of us are aging, I think your reference to upper age, I like that term. Certainly organ donation or otherwise, but that was a very lovely way of describing also how we need to be prepared to get our ducks in a row. So thank you so much, Wallace. That's great. For those of you who are still on, just to note, this was our final speaker as part of our spring speaker series called Empowering Aging, with information choices and well-being. We will also be moving to a new fall series. I think Jamie might have a slide there we can share. We attempt to have a different speaking theme for usually 3 months at a time. Our fall speaker series will be on everyday actions for healthier aging. We also have our first speaker confirmed. We typically like to offer one presentation a year in person for those of you who are local in Vancouver. And so our first one will be on sleep, something we all achieve to have meaningful, effective sleep. And so that presentation will be on September 28th in person at Van Dusen. Registration will open in August, so please do sign up for our newsletters from Dialogue on Aging, and we hope to see many of you there. Thank you so much again, Wallace, for your excellent review. That was a really great presentation, and I see wonderful comments in the chat. So thank you to everyone for being able to join today.
My pleasure. Thank you so much. It was a privilege.
Take care.